Hello everyone, my name is Arya Kudchadker and I am a legal intern at LEXIS and Company. I am also a student of 4th year BA LLB at GR College of Law, Margao, Goa, under the Goa University. Today I am going to be talking on the topic of unlawful assembly. And the purpose of making this video is to spread awareness about the offence of unlawful assembly under the Indian Penal Code. So as per the Indian Penal Code 1860, unlawful assembly is an assembly of 5 or more persons if their common object is to overcome by criminal force or show of criminal force the central or the state government or parliament of the legislature of any state or any public servant is the exercise of the lawful power of such public servant to resist the execution of any law or any legal process or to commit any mischief or criminal trespass or other offence or by means of criminal force or to show of criminal force to any person, to take or obtain possession of any property or to deprive any person of the enjoyment of a right to way, the use of water, other incorporeal rights of which he is in possession or enjoyment, or to enforce any right or supported right, or to compel any person to do what he is not legally bound to do so, to omit to do what he is legally entitled to. An assembly which was not unlawful when it assembled may subsequently become unlawful assembly. Thus, there are 5 types of unlawful assembly. An assembly of 5 or more persons with one or more of the above objects becomes an unlawful person. Membership. The assembly must consist of 5 or more persons. An assembly of 4 persons will not be an unlawful assembly. Members of an unlawful assembly. Whoever, being aware of the fact which rendered an assembly or an unlawful assembly, intentionally joins it or continues in it is said to have been a member of an unlawful assembly. For being a member of an unlawful assembly, the punishment prescribed by the code is imprisonment up to 6 months or fine or both. Liability of a member of unlawful assembly. One type of constructive criminal liability is dealt with by section 34, which deals with the liability of one person for the acts of the another. Section 149, which is the second type of constructive criminal liability, provides that if an offence is committed by any member of an unlawful assembly in prosecution of a common object of the assembly, or such as the member of that assembly knew to be likely to be committed in prosecution of that object, every person who at the time of committing that offence is a member of the same assembly is guilty of the offence once the common object ceases to exist. Section 149 will not apply. Members of an assembly may have a community of objects not only up to the certain point beyond which they may differ in their objects, and the knowledge possessed by each member of which is likely to be committed in the prosecution of their common object will vary, not only according to the information at his command, but also according to the extent to which he shares the community of objects. Section 149 creates a specific offence and deals with punishment of that offence. The emphasis is on common object. There is no question of common intention in section 149. Thus, every person who is engaged in a prosecution of the same object, although he has no intention to commit the offence, will be guilty of an offence which fulfills or tends to fulfill the object which he is himself engaged in prosecuting in the circumstances mentioned in the section. As per the case of Shiv Mahadev Singh versus State of Bihar, the common object of unlawful assembly is question depends firstly on whether such objects can be classified as one of those described under section 141 IPC. Secondly, such common object need not be the product of prior concert but may form on the surf of the moment. Finally, the nature of the common object is a question or the fact to be determined by considering nature of arms, nature of assembly, behavior of the members, etc. Mere presence in an unlawful assembly cannot render a person liable unless there was a common object and he was actuated by a common object and that the object is one of those set out in section 149. But the common object is an unlawful assembly is not proved, the accused person cannot be convicted with the help of the section 149 as per the case of Dara Singh versus State of Bihar. So please do like, share, subscribe and comment on my video, and do like and subscribe my channel LexCliq. Make sure to press the bell icon to get notifications when we post a video. Also, please give a feedback on this video and previous videos which you can see on this YouTube channel. Also, if you have any questions related to this video or any previous videos, please post it on the comment section below. I will reply as soon as possible. Lastly, this video doesn't solicit any type of promotion or advertisement as per the guidelines of Bar Council of India, and sole purpose of making this video is for educational purposes only. Thank you.